Law of Crimes. Indian Penal Code 1860. Concept of crime and the law of crimes in India. Chapter 1. Meaning of crime. Definition of crime. The word crime is derived from Greek expression krimos, KRIMOS, which means social order, and it is applied to those acts that go against social order and are worthy of serious conditions The word crime has not been defined in the Indian Penal Code. The word crime has not been defined in the Indian Penal Code. Definition given by eminent criminologists and sociologists are as given below. As a public wrong, Sri William Bollockstone defines crime in two ways. One, crime is an act committed or omitted in violation of public law, forbidding combining it. 2. A crime is a violation of the public rights and duties due to the whole community, considered as a community. Sri James Stephen, while modifying the Blackstone's definition modifies, states a crime is a violation of a right, considered in reference to the evil tendency of such violation as regards the community at large. As a public wrong, as moral wrong. As moral wrong. According to Raphael Garfello, crime is an immoral and harmful act that is regarded and criminal by public opinion because it is an injury to so much of the moral sense as to community. A measure which is indispensable for the adoption of the individual to society. As a conventional wrong, Edwin Sutherland says, criminal behavior in violation of the criminal law, no matter that the degree of immunity, reprehensibility, or indecency of an act. It is not a crime unless it is prohibited by the criminal law. The criminal law, in turn, is defined conventional as a body of specific rules regarding human conduct which have been promulgated by political authority, which apply uniformly to all members of the classes to which the rules refer, and which are enforced by punishment administered by the state. Characteristics which designates this body of rules regarding human conduct from other rules are therefore politically specifically uniformity and penal section as a social wrong. According to John Gillin, a sociologist, crime is an act that has been shown to be actually harmful to society, or that is believed to be socially harmful by a group of people that has the power to enforce its beliefs, and that places such crimes under the ban of positive penalties. Positive penalties as a procedural wrong. As a procedural wrong. Yes, Austin says, Austin says a wrong which is pursued by the sovereign or his subordinates is a crime. A wrong which is pursued at the discretion of the injured party and his representatives is a civil injury. According to Keeney, crimes are wrongs whose sanction is punitive and are in no way remediable by any private person, but are remediable by the crown alone. It remediable to at all. According to Fontaine, a crime we find that the normal modes are that the state has power to control the procedure, to remit the penalty or to inflict punishment. Quinton has defined crime as a crime today would seem to be any undesirable act which the state finds it most convenient to correct by the institution of proceedings for intention of penalty instead of leaving the remedy to the discretion of some injured person. Other definitions. As per Oxford English Dictionary, crime is an act punishable by law as forbidden by statute or injuries to the public welfare. Halsbury's Laws of England provides a crime is an unlawful act or default which is an offence against the public and renders the person guilty of the act or default liable to legal punishment. Mitchell and Adler state the most precious and least ambiguous definitions of crime is that which definition is as behavior which is prohibited by the criminal code. According to B.A. Wrotley, a crime is an offence against the law and is usually an offence against the morality, against a man's social duty to his fellow members of society. It renders the offender liable to punishment. Ashburn states, crime is an act or default which tends to the prejudice of the community and forbidden by law on pain of punishment inflicted at the suit of the state. Donald Tuft definition. Crime is a social injury and an expression of subjective opinion varying in time and place. Miller defines crime to be the commission of an act which the law forbids or commends under pain of a punishment to be imposed by the state by a proceeding in its own name. Below, W. Tappan defines crime as unintentional act or in violation of criminal law committed without defense or justification and sanctioned by the law as felony or misdemeanor. Schillen defined the crime as an act which offends the basic moral statements of pity, revolution against the voluntary intention of suffering or others and property in respect of the property rights of those. Eleanor Habitude Johnson states that crime is an act which the group regards as sufficiently menacing to its fundamental interest to justify formal reaction to restrain the violator. As per C. Johnson, crime is a legal wrong, the remedy for which is punishment of the offender at the instance of the state. Professor Hart said that in order to them an act as crime, the following two questions must be answered in the affirmative. 1. Where the active which offenders and moral feelings in is harmless independently of its repression on the general moral code, and whether the whole moral fabric of the society would go to pieces if the offending act is not made criminal. J.W. Cecil Tuner was given the following description of a crime. It is a broadly accurate description to say that nearly every instance of crime presents all of the three following characteristics. 1. That it is a harm brought about by human conduct, which the sovereign power in the state desires to prevent. 2. Among the measures of prevention selected is that threat of punishment. 3. That legal proceedings of a special kind are employed to decide whether the person accused did in fact cause the harm and is, according to law, to be held legally punishable for doing so. We find that it is very difficult to get a definition of a crime suitable to all countries for all the time. The following are, according to German Hall, inter and overlapping definition of crime. 1. There must be some external consequence of harm to social interests. 2. The harm must be prohibited by penal law. 3. There must be conduct there is intentional or recklessness action or inaction that brings prohibited harm. 4. There must be mens rea or criminal intent. 5. There must be concurrency of mens rea and conduct. 6. There must be a causal relation between the legal prohibited harm and the voluntary misconduct. 7. There must be legally prescribed punishment or that of punishment. Nature of crime. Nature of crime. Law prescribes certain standards of conduct to be observed by the people in society. These standards have the approval of the society in general. Any deviation from the standards of behavior fixed by the society is punished. Therefore, such conduct as does not occur with the prescribed standard is loosely known as a crime. In generally terminology, a crime may be defined as an act fit for serious condemnation or an act which is looked down upon with disprohibition. In legal physiology, it would be land considers fit for punishment and the person doing any act in contravention of the same is subjected to the punishment prescribed therefore. To make it clear, a crime may be described as an act committed or omitted in violation of public law forbidding or committing it. All acts tendering to the prejudice of the community are not crimes. Unless they are punishable under the law, a crime is an act or omission which is prohibited by law. A crime is injuries to the public. It is punishable by the state for the welfare of public at large. A crime contains two basic elements. There is one mala in se and mala prohibita. For example, some of the traditional crime like murder, theft and rape etc. are known as a mala in se, while various other crimes in which there is no element of immorality in the traditional sense are known as mala prohibita. They differ from place to place. Crime are not static. They are relative. Crimes differ from contrary to country to country and time to time. For example, adultery is mala prohibita in India, and a person who commits the offence of adultery is punished under law, whereas in England it is not prohibited. Before the 18th century, slavery was widely prevalent. The Africans were tried as animals and were taken to America and other countries, selling, harassing, and even killing themselves was legally upheld then. There is no slavery at present and it is punishable in all the states. Polygamy is prohibited among Hindus by the Hindu Marriage Act 1955, but there is no such law of Mohammedans. They can marry upon 4 women. There is a rigid difference between crime, sin, vice, and social wrongs as well as moral wrongs. The reason is that a crime is prohibited by law. There is also a prescribed procedure and machinery to punish the persons who commit crime, whereas there is no mechanism to punish anyone in the case of the sin, vice, and social or moral wrongs. Sin is considered with religion. Therefore, any person commits a sin, it is said that he will be punished by the God himself. What is sin is dictated by that particular religion to which the belongs. Likewise, vice, social and moral wrongs are wrongs only in the eye of moral codes or in social rules, but they are not recognized wrongs in the eyes of law. In the eyes of law, chapter 1 definitions. Okay. Next class, next time. Thank you.